I think we wanted to come back to talk about AB 1003, right?
Yes, wage theft.
Awesome, but not from the employee standpoint.
No, so when you say the employee standpoint, wage theft from the employee standpoint is oftentimes when you clock in and you're not working, but the employer is basically paying you. That's not what we're talking about. What we're talking about is definitely different. It basically says that it is a felony if an employer intentionally fails to pay wages in the amount greater than $950 to one employee, or $2,350 in aggregate to two or more employees within a 12-month period. Wow, that was a lot of info.
Yeah.
So break it down for us, Marie.
Okay, first break it down. This is just another way for plaintiffs' attorneys to bring class action lawsuits and add another claim into their civil action for penalties. Because what happens if you, again, I love the words. So it is wage theft is now considered grand theft under the California Penal Code. And the penalty is $200 per employee per pay period that they were underpaid, which again, it's just sort of like the POG Act. I'm using words that probably some people don't know, but it just adds to the value of the class action claim. Now, when I say I love words, it says the intentional deprivation of wages. So that would seem, well, intentional means you have to know you're doing it. Like I offered Rosandra $20 an hour. I'm only going to pay her $18 an hour. That would be your version, my version of the word intent. Even though it says intent, the word intent in the California Labor Code means I offered Rosandra $20 an hour. I accidentally paid her 18 and didn't do an audit to make sure that I didn't miss out that $2. That was an intentional act because I wrote her a check for $18 an hour. So intent really doesn't mean anything in this law. And I want to be clear about that. It's one of those very frustrating aspects of the way that laws are written.
What came to my mind the first time I heard about this law, and what's frightening is employers facing not only fines, but they're facing a felony charge, which is that's just like, if that doesn't make you frightened, then I don't know. But what came to my mind when I first heard about this law is, and we hear this over and over again when we meet with clients, oh, we don't pay overtime here. That would be intentional, right?
That would be intentional, and you actually have clients that say that?
Yes.
Okay, see, I was less the voice.
After there are clients, they are paying overtime. But when we first meet them, they go, oh, we don't pay overtime here.
Yeah.
Oh, yes, you will pay overtime if you're going to be our client.
But, okay, like there, I guess nothing should surprise me
It's frightening
anymore.
how many times we hear that.
No. The other part about this is when the employer will often say, well, isn't it up to the employee to prove that I did this on purpose?
Oh, I just settled a class action at mediation on Tuesday of this week for well into the 6 figures or 7 figures, unfortunately. And we had to go to a meeting with a bunch of people to see if this is going to actually go through. And a couple of people at that meeting, again, said, well, why is this our responsibility? It should be our employees' responsibility. And I had to explain that California, the burden is on the employer to audit those records and make sure that everything is right. So,
well, thank you for joining us today. Another interview with Marie Davis. Lendiger, Verano & Davis is an employment law firm exclusively representing employers and business owners. Our employment attorney, Marie Davis, is based at the Ventura County, and you can contact her directly at the number here, 818-986-7561. And the extension is 106. Our headquarters is based in Encino and another satellite office in Pasadena. Please don't forget to like our video, subscribe to our YouTube channel, and turn on the notification bell to get video updates on employment law. And until next time, we thank you for joining us and have a great day.